Doma dead. So before they could argue the application, because the application seeks to declare the current strike illegal. The application seeks an order that the teacher should be ordered to go back to the classroom. We raised the objection that we only served yesterday. We need to respond fully. We need time to respond to the application. And we were outlining the issues that we would like to raise in our response. One of them being that a party who is in contempt of court orders cannot have audience before the Supreme Court. And that is the issue that we shall be responding to. The TSC is in contempt of the court orders, the Labor Relations Court, the Court of Appeal. Their application for stay was dismissed by the Supreme Court. So they have to comply with the court orders regarding paying the teachers their enhancement. And until they pay, we are saying they cannot have audience before any court. And the rationale for that is very simple. If you are defying the court orders, you cannot be going back to the same courts to ask for orders to be made in your favor. That's one of the points. Second point that we are saying is that the current petition is not a new petition. This application for the strike to be made illegal, teachers to be ordered to go back, should be made before the same court that delivered the judgment. If you see the application, it is annexing the judgment of Doma dead. So we are arguing that that is the court to which they should make the application for contempt of orders that the teachers should go back to the classroom. Number three, we are saying the time has come for this very, very important constitutional issue, because you see the section, I think it's section 69, in the Employment Act, Labor Relations Act, that requires workers to give a strike is in an act of parliament which was enacted in 2007. That is prior to the 2010 Constitution. If you look at section 7 of the 6th schedule, it says that all existing laws will now have to be interpreted in a manner that brings the law into harmony with the new Constitution. With the 2010 Constitution, unlike in the old Constitution, the 2010 Constitution in Article 41 gives workers the right, constitutional right, to go on strike. So we want to know whether a section in a legislation that predates the new Constitution can be used effectively to nullify an article in the Constitution. We are saying this issue is so important, going beyond the current parties in this dispute. It's an issue, constitutional issue, that will affect the constitutional rights of all the workers, and that it is one that is so weighty, it should be heard by a bench of 3 judges. So this is what we were outlining, and she gave directions that we are to put all this in writing, including submissions. The other person is to respond, and we'll come back for arguments on these issues on Thursday next week. She did not declare the strike illegal. She used the language that the strike is unprotected. Whatever that may or may not mean will be gone into when we address the issues we are raising fully, because she cannot make any findings before she hears submissions and arguments from both sides. I think it was a little baffling for her to start talking about a strike not being protected before hearing the arguments and the submissions. But the bottom line is that there are no interim orders, there are no orders issued. It's directions that she gave of how the parties are going to put in their written submissions. And we come back on Thursday, which we are quite happy to.
Thank you.